I'm Sean Forrester, the Managing Criminal Defense Attorney with the Lerner & Rowe Law Group. Often when clients first come into our office, they want to know what a lawyer can do to help. There are generally three areas that a criminal defense lawyer is going to look at when investigating or when evaluating a DUI investigation. The first is going to be the validity of the traffic stop. If the police officer doesn't have a legal basis to pull you over, we can file a motion to suppress, and that can suppress anything that happens afterwards. In order for the law enforcement officer to pull over your vehicle, he either needs reasonable suspicion that you were committing a traffic violation or probable cause that you committed a crime. If he doesn't have these, sometimes we call that a fishing expedition, and it's a bad stop, and we can make that motion to suppress. The second area that we're going to look at is that contact you have with law enforcement on the side of the road. This is going to be the administration of the field sobriety test, the observations of the officer, the results of any preliminary breath testing, any admissions that you may make. All of this is what we look at to see, does the police officer have probable cause to arrest you for a DUI? The third area that we're going to look at is the scientific testing. If you're arrested for a DUI, you're going to be transported to a mobile unit, a substation, or a police station to give a sample of either your blood, breath, or urine for purposes of determining your BAC. We look at everything from the credentials of the phlebotomist who draws your blood if it's a blood draw. We look at whether the officer is certified to use the Intoxilyzer 8000. That's the breath test machine that might use. If it's a blood test, they're going to have to package, label, store, and transport the blood down to the lab. This is where we look for breaks in the chain of custody. The last area that we're going to look at is the actual testing process itself. If it's blood testing, your vial is going to be sent to the lab for testing into a machine that's called a gas chromatograph. It's not a perfect science, there's plenty of error rates, but it's really something that if you have an experienced criminal defense attorney, we know how to challenge it, we know what to look for by requesting things such as the batch data to see if the results are believable and reliable. During a DUI investigation, the police officer may ask you some questions like, where are you coming from? How much have you had to drink? Where are you going? Again, you do not need to answer these questions. You can absolutely exercise your right to remain silent. The only questions you must answer are, what's your name, address, date of birth, and place of employment. Remember, what police are doing is trying to develop probable cause, meaning showing that it's more probable than not that you were impaired by alcohol or drugs. By refusing to answer these questions and by saying simply you don't want to answer any questions without a lawyer present, you have the constitutional right to give that invocation, which means the police must cease all further questioning. If you're being investigated for committing a DUI, the law enforcement officer is likely going to ask you to participate in a series of field sobriety tests. This is what we know as the walk and turn test or the stand on one leg. What law enforcement is doing is trying to develop probable cause to arrest you for a suspicion of DUI. Our advice is politely decline these tests. You do not need to do them. They don't help your case. They're really just a tool of law enforcement to try to get more evidence, more information, or proof that you are operating a motor vehicle while impaired. So when you're in the field and the police officer is doing the DUI investigation, you've not yet been arrested, decline the field sobriety test, decline the preliminary breath test, the little handheld box that he holds up to your mouth, decline to make any admissions or acknowledgments as to what you were doing earlier in the night. However, once you've been arrested, you've been taken into custody, and you've been taken down to that police station, our advice is consent to those tests. If you've been arrested for DUI, you've likely been given two important documents. The first is the citation. It's usually a white sheet of paper that's going to list out the DUI charges. Examples would be you'll see DUI drugs vapor combo. This doesn't mean that it was a DUI drug or a DUI alcohol. It's actually what we commonly know as being DUI impaired to the slightest degree. You may also see other DUI charges such as DUI .08 or more or DUI .15 or more. At the bottom of that citation, you're going to have your court date as well as the court where you need to appear. You'll also be given a pink or a yellow sheet of paper with the bold letters at the top that says Implied Consent Admin Per Se Affidavit. This is a document from MVD. This can initiate a suspension of your license. At the bottom of this document, there's going to be two boxes that can be checked. If you consented to a testing of either your blood, breath, or urine, the bottom box is going to be checked, which means you may be looking at a 90-day suspension of your license. If you refused to give a sample for scientific testing and the cops had to get a search warrant to either draw your blood, you're going to see this top box checked, and that's going to mean that they're looking to suspend your license for 12 months. The issues with MVD are time sensitive. The cop is likely going to tell you that you've got 15 days from the date that this is served on you to request a hearing to challenge that proposed suspension. This is something a criminal defense lawyer can help you accomplish. By requesting a hearing, you, one, suspend the date of suspension for your license, but not only that, you get the chance to go in and challenge whether or not the suspension should be upheld. So often we get asked the question, what can a DUI lawyer or a criminal defense lawyer do to help? We have the experience and the knowledge to investigate these cases. Our job is really to critique the investigation of law enforcement. It's through that experience and knowledge that we have the know-how to put you in the best position to try to get the charges reduced or dismissed. If you're convicted of a DUI in Arizona, you're looking at jail time, fines and fees of thousands of dollars, installation of the ignition interlock device in your vehicle. That's that little machine that you've got to blow in to get your vehicle started, blow in it periodically. Mandatory drug and alcohol screening, drug and alcohol classes, usually participation in the Mothers Against Drunk Driving Victim Impact Panel, as well as any other terms ordered by the court. For these reasons, given the harsh penalties, we recommend come sit down with us, do the free consultation, and we can let you know what we can do to help. If you've been arrested for a DUI or any criminal offense, give us a call at the number below or fill out the free intake form on our webpage to schedule that free consultation to meet with me or another attorney in my office. We'll go over the facts of your case, let you know your options, and let you know what we can do to help. I'm Sean Forrester, the managing criminal law attorney with the Lerner and Rowe Law Group. Our team of defense attorneys has over 75 years combined experience in criminal law, including former prosecutors and a board-certified specialist. At the Lerner and Rowe Law Group, we understand that it's scary to be charged with a crime and that our clients are entrusting us with the biggest problem they'll ever face. Let us be that guiding hand and walk you through this complicated process. We fought for clients all across the state. Let us put our skill, knowledge, and experience to work for you.